Thank you for joining the paid webinar. Please note we will be recording this presentation. I'd like to introduce Brian Jarrett, Acting Administrator of the Wage and Hour Division.
Welcome to the department's launch of our new Payroll Audit Independent Determination, or PAID, program. Thank you for joining us today as we kick off this exciting pilot. We appreciate your interest in both this program and in complying with the law. We look forward to walking you through the details of the program and to providing straightforward answers to any questions you may have. I'm Brian Jarrett, Acting Administrator for the Wage and Hour Division, and I have to apologize in advance to you all. I'm feeling a little under the weather today and am sounding a bit nasally, but if you'll bear with me, we'll get through this together. Joining me today is Senior Policy Advisor Keith Sonderling.
Hello everyone, I'm Keith Sonderling, the Senior Policy Advisor in the Wage and Hour Division. Brian and I welcome you to this presentation and thank you for your interest in the PAID program and for joining us today. We are confident that you'll find the presentation informative. Our goal is for you to have a clear understanding of the program, how you can participate, and how it ultimately benefits employers, employees, and taxpayers alike. After the presentation, we will have a question and answer session, so throughout the presentation, please submit your questions for us to answer at the end. Now, let's begin.
Today's presentation will provide you with some of the details of our new PAID program, explain its scope, its purpose, and all of the benefits it offers for all parties. We'll get into the nuts and bolts of how you can participate, what you can expect as you work your way through the process, and the conditions that must be satisfied for you to participate. We'll also discuss the sorts of issues that the program can help you resolve and those that it cannot. You'll walk away today with some concrete answers to questions about how this all works.
PAID is a self-audit program that the department is offering to enable resolution of inadvertent minimum wage and overtime violations under the Fair Labor Standards Act. It allows and encourages employers to come forward in good faith to proactively work with us to fix inadvertent violations. The department will implement this pilot program nationwide for approximately 6 months. At the end of the pilot period, we will evaluate its effectiveness, consider potential modifications, and decide if this will become a permanent program.
PAID benefits all parties involved. First, it's a win for employees. Employees deserve the wages they earn. When employers make mistakes, the PAID program helps employees receive their overtime and minimum wages as quickly as possible. The PAID program protects the employees' rights and allows them to make the decisions that are best for them. Second, it's a win for employers. The PAID program provides a framework for proactive resolution of potential overtime and minimum wage violations under the FLSA. The program allows employers and employees to resolve such claims expeditiously and without litigation. Third, and finally, it's a win for taxpayers. The efficient and effective use of taxpayer resources is a top priority for the Department of Labor, and by streamlining both compliance and resolution of claims, the Wage and Hour Division can concentrate enforcement resources on those continuing to violate the law and who have not come forward. This helps us in our mission to protect workers and to level the playing field for employers who are already operating in compliance.
Let's talk a little more about how this benefits employees. PAID offers significant benefits to employees. This program ensures that more employees receive the back wages they are owed faster. Employees will receive 100% of their back wages being paid by their employer without having to pay any attorney's fees or litigation expenses. The PAID program encourages employers to proactively conduct audits that otherwise would not necessarily occur. Before an employer can use PAID, the program requires them to review all relevant compliance assistance materials, carefully audit their pay practices, and agree to permanently correct the pay practices at issue. If employers discover overtime or minimum wage violations, they can come forward and work in good faith with the department to correct their mistakes and provide the compensation due to their employees in an expedited manner. Absent this program, such employer-driven audits may not take place. The program helps current employees now and protects future employees from incurring similar issues.
You may wonder if this program requires employees to surrender any rights. It does not. It is purely the employee's choice whether to accept the payment of any back wages due as a result of self-audits under this program, and employers are prohibited from retaliating against the employee for his or her choice in that matter. If the employee chooses to not accept the payment, they will not release any private right of action. If the employee chooses to accept the payment, they will release claims for only the potential violations in the time period identified by the scope of the self-audit. Additionally, by allowing employers to participate in the paid program, the department does not waive its right to conduct any future investigations. Employees are further protected because employers also cannot use the program to repeatedly resolve the same violations, as this program is designed to identify and correct non-compliant practices. Under the paid program, the department expects that many more employers will self-report and, as a result, that many more employees will be paid more quickly. We expect that each paid case will require less time and fewer resources than it takes to resolve full investigations, freeing the division's resources to focus on bad actors, to otherwise help America's workforce, and to continue to level the playing field for employers who play by the rules.
While paid offers clear benefits to employees, it also offers certain benefits to employers. The program enables employers to expeditiously resolve inadvertent minimum wage and overtime violations without the expense or delay of litigation. All employees who accept payment will waive their right to sue for the issues resolved under the scope of the self-audit. Further, employers that voluntarily self-report and take the corrective action required will not be subject to liquidated damages or civil money penalties as a condition to finalize settlements. However, without exception, employers that participate in the program will be required to pay 100% of the back wages due for each violation they seek to resolve. The paid program provides a framework for proactive resolution of potential overtime and minimum wage violations under the FLSA. The program's primary objectives are to resolve claims expeditiously and without litigation, to improve employers' compliance with their required overtime and minimum wage obligations, and to ensure that the affected employees receive the back wages they are owed faster. Aside from providing employees with their earned but unpaid back wages, the program works to increase awareness of the law through required employer training. These prerequisites to participate in the program help current employees now and protect future employees from incurring the prior wage practices. Generally, if employers better understand their legal obligations and take the time to review their current policies and practices, it also helps the department achieve broad compliance. Further, the program helps to broaden the impact and improve the efficiency of the Wage and Hour Division. It allows our nationwide staff to expeditiously work with employers to resolve unintentional violations, freeing up their time so that more efforts and resources can be focused on egregious violators.
So to participate in the paid program, you must be an employer that is 1, covered by the FLSA, 2, interested in proactively resolving minimum wage or overtime claims under the FLSA, and 3, willing to commit to future compliance under the FLSA. Any covered employer acting in good faith that is willing to complete the program requirements may participate. Please keep in mind that the pilot program is limited to violations of the minimum wage and overtime provisions of the FLSA. There are, though, some circumstances that preclude an employer's participation in paid.
Some circumstances will prevent an employer from participating in paid. An employer may not participate in the program to resolve any issues for which the Wage and Hour Division is already investigating the employer or which the employer is already litigating in court, arbitration, or otherwise. Similarly, an employer may not initiate the process when an employee's representative or counsel has communicated an interest in litigating or settling the issue. Also, employers cannot use the program to repeatedly resolve the same violations. This program is designed to identify and correct non-compliant practices. As a further example, if the department determines the employer is acting in bad faith, we may decline to accept the employer into the paid program. Ultimately, the decision whether to accept or decline an employer's participation in the program is a decision made by the department based upon our discretion to determine whether we can achieve efficient resolution of proposed self-audits through the paid program.
Again, this program currently covers potential violations only of the FLSA's minimum wage and overtime requirements. This could include, for example, violations based on alleged failures to pay overtime at 1 1/2 times the regular rate of pay, or the misclassification of employees as exempt from the FLSA's minimum wage and overtime requirements. Other examples could include hours worked issues leading to minimum wage and overtime violations, such as failing to pay for short work breaks, unpaid pre-shift or post-shift work, etc. Another example could include deductions from pay leading to minimum wage violations, such as deductions made for uniforms or damage to the employer's equipment. Regular rate issues, such as when bonus payments are erroneously excluded from overtime calculations. And as yet another example, misclassification of employees as independent contractors resulting in minimum wage and or overtime violations. We want to encourage employers to participate in this program. To accomplish that goal, we will consider a wide variety of minimum wage and overtime violations. The pilot program will not at this time accept employers who wish to self-report violations under other sections of the FLSA or under other statutes, such as FLSA child labor violations or prevailing wage rate violations under the Service Contracts Act. So once an employer understands the benefits to both their business and their employees, how do they go about participating? How does this program actually work? We have the process very clearly laid out on our website at dol.gov/WHD/paid. It's a simple process designed not only to remedy the compliance issues at hand, but also to improve compliance moving forward. We provide step-by-step instructions that guide employers through every requirement.
The first step employers interested in participating should take is to visit our website to familiarize themselves with the program. That website is dol.gov/WHD/paid. The next step is for the employer to verify that they are covered by or subject to the Fair Labor Standards Act. You will recall that earlier in the presentation we mentioned a few circumstances that would disqualify an employer from participation, such as currently litigating or being investigated for the same compensation practices brought forward. Accordingly, employers will be asked to attest their eligibility prior to their acceptance into the program. The next step is to review the compliance assistance and educational materials on our website. This review enables the employer to conduct their audit with the knowledge of what the law requires. Once this review is complete, our website automatically generates a certificate of completion. This certificate will ultimately be submitted to the agency as an attestation that the employer reviewed all the required materials. After reviewing these materials, employers must then carefully audit their compensation practices for potentially non-compliant practices.
If any potentially non-compliant practices are found during the employer's self-review, the employer then must 1. Specifically identify the potential violations at issue, 2. Identify which employees were affected, 3. Identify the time frames in which each employee was affected, and 4. Calculate the amount of back wages the employer believes are owed to each employee. Next, the employer should contact the Wage and Hour Division to discuss the issues for which it seeks resolution. Our website will direct employers to the district office nearest their location for this purpose. District office staff will then explain to the employer the manner in which they must submit required information, including the following. First, the names, addresses, and phone numbers of all affected employees. Second, back wage calculations along with supporting evidence and methodology used to make those calculations. Third, payroll records and other relevant evidence. And fourth, records demonstrating hours of work of each affected employee during the time frame at issue. Employers must also submit, first, records to show that they have corrected the compensation practices to comply with the FLSA. Second, a concise explanation of the scope of the potential violations for possible inclusion in a release of liability. Third, a certification that the employer reviewed all of the paid program's information, terms, and compliance assistance materials. And fourth, a certification that the employer meets all eligibility criteria of the paid program. The program also requires that participating employers attest to future compliance.
The department will then evaluate this information and contact the employer to discuss the next steps, including whether the employer may participate in the paid program. If accepted into the program, the department will provide the employer with the proposed scope of the release of liability for the potential violations presented. At that point, the employer and the department may discuss the collection of any other information necessary to confirm the back wages due for the identified violations. This may include reviewing sample payroll records, Under certain circumstances, it may also include contacting certain employees to conduct interviews to verify facts when, for example, deficiencies in payroll records require employees' hours to be reconstructed. It is important to note that if you pay back wages to your employees before the department reviews and assesses the back wages owed, those employees will not have waived their rights to pursue a private lawsuit for these potential violations under the FLSA, because the department did not supervise the settlement of these back wages. After the department verifies the amount of back wages due, a summary of unpaid wages is issued. Additionally, release forms describing the settlement terms for each employee will be distributed to the employees in order for them to sign to receive their wages. The language in the release of claims provided in the form will be limited only to the issues for which the employer agreed to pay back wages. Employers are responsible for issuing the payment. The department will not distribute back wages. The payment to the employees must occur by the end of the next full pay period after the employer receives the summary of unpaid wages from the department. After payment is issued to the employees, the employer must expeditiously provide proof of payment to the department. At that point, the process is complete. The Wage and Hour Division records the self-audit in its database and considers the action closed. Should the employer have additional compliance questions or need any assistance moving forward, the employer is of course welcomed and encouraged to continue a relationship with the department even after the formal process has concluded. The department is strongly committed to providing employers the tools they need to understand their responsibilities and to comply with the law. That conversation need not conclude with the self-audit.
We would now like to open it up to answer your questions. We'll do our best to get in as many as we can.
Now we want to open it up to some question and answers, and one of the questions we've been receiving is about finding more information on our website. And we thought it'd be prudent to walk through our newly designed paid website and show you where you could find additional information and also how you could participate in the program and what you need to do before contacting us to start your self-audit. So on your screen now should be the Wage and Hour Division's newly launched paid website where you can find all the information you need to participate in this program. On the bottom of the page, I just want to point out where it says attend a webinar about paid, which is what you're attending right now, we will replace that link with an archived version of this webinar. So if you've missed anything during the webinar so far, you can go back and watch it at any point. So some background information on how the paid program works can be found in the first tab, and a lot of this has been gone over in the webinar, so I will quickly go through it. You'll find some of the prerequisites you need to review prior to participating in this program and the steps that need to occur before contacting Wage and Hour. And the same with participating in paid. You'll see under coverage, first and foremost, your company needs to be subject to the Fair Labor Standards Act. So we link to the fact sheet 14, which is coverage under the Fair Labor Standards Act, where you can review to see if your company first qualifies for FLSA coverage, whether it be a private business or be a state or local government agency. And we have different requirements there. And then some questions about your employees, again, all to determine coverage. So once you've determined that the Fair Labor Standards Act applies, then you need to determine your eligibility to participate in the paid program. And first and foremost, again, covered by the FLSA, and to make sure that none of these other prerequisites are not there before participating. Then comes reviewing the compliance assistance materials. And as we discussed, a lot of this is to make sure that you all have read the compliance assistance material on the Wage and Hour website to ensure what your pay practices are and to ensure what the law requires. You'll see here under certificate information, we talked earlier about the certificate you need to present to Wage and Hour showing that you've completed all these prerequisites. To be able to get to the certificate stage, you need to submit your name and your business name. But please be aware that we do not collect the names entered into our system at the point where users are accessing the compliance assistance review. We want to do everything we can to encourage employers to read and understand our information. So we will not in any way collect or use data about who accesses our information as a basis for initiating investigations or any other actions. So we really want to encourage you to go through this process and submit your information. So we will walk through it now for you all so you can see the process. So you enter your name and your business name, and you click Next. Then you'll have to go through 12 screens before being able to print your certificate. And each screen has a hyperlink to various compliance assistance materials that's required before participating in this program to make sure that you understand your obligations and that you know how to correct your pay practices through our website. So the first one is the handy reference guide to the Fair Labor Standards Act. You click on it and a pop-up window comes up, and there it is, the handy reference guide to the Fair Labor Standards Act. Once you've read this, you go back to the page, click Next, and the next is does the Fair Labor Standards Act apply to my business? And it's a video. And this is our new video program that we've launched just a few weeks ago, and I'll let Brian talk about these videos and why the Wage and Hour Division decided to provide these videos to the public.
Yeah, so I wanted to give a quick plug on these. We have about 5 of these now, and they cover some of the most foundational issues under the FLSA, minimum wage, overtime coverage, and the like. And you'll see when you watch these videos that they're short. I think this one's about 5 minutes. They're stripped of legalese. They're put in plain language. Really, it's part of an ongoing mission here in Wage and Hour to make information more accessible to employers. We understand that not all employers digest information in the same way and that some have different levels of understanding. So I think these videos are an excellent way to get employers the most foundational information they need at a high level to understand their legal obligations under the FLSA. And this is part of an ongoing project. We're going to be releasing more videos in the future on other topics, but for now we've incorporated many or all of the videos into the 12 steps that you have to click through to get your compliance certificate. But they're good videos. I hope you like them. There was a lot of work that went into them.
And after you watch the videos, you go back to the paid site. Next question is, which workers are employees entitled to FLSA wage requirements? And again, it's a link to fact sheet 13. You cannot proceed forward until you've opened it and reviewed the fact sheet. So we'll move along. The next topic is a video. It's minimum wage. What minimum wage requirements apply to my business? And again, it's another one of our compliance assistance videos that Brian just mentioned. The next step is which employees must be paid at least the federal minimum wage, which brings you to our question and answers about minimum wage. So part of this program is really, we want to highlight the voluminous amount of compliance assistance material that's been available on the Wage and Hour Division website for some time. The next is hours worked. Do I have to pay for that time? And again, it's another one of our videos on a very often asked about topic is what time do you have to pay for under the Fair Labor Standards Act? Screen 7 is hours worked under the FLSA, which brings you to our fact sheet. And like the others, we encourage you to review all fact sheets prior to continuing to ensure the information you give to us for your self-audit correlates with the existing requirements under the Fair Labor Standards Act. And again, another video, this one on overtime. The next is a review of fact sheet 23, which is overtime pay requirements under the FLSA, which helps you with your determining overtime compensation.
We're almost done.
Almost there, 10 of 12. And that's exemption for executive, administrative, professional, computer, or outside sales. And these go through the Section 541 exemptions under the Fair Labor Standards Act. And there's plenty of material on the website regarding 541 exemptions, and you can click each one of these exemptions for more information. Grade 11 of 12 is our record-keeping requirements under the FLSA. And then once that's reviewed, one more, deductions. It's one of our compliance assistance videos. This is often an area where employers confuse, so we spent a lot of time on this video to make sure it's easy to understand so everyone can meet their obligations. And then finally, you get your certificate. And there it is. That's what it looks like. And that's what you'll print to show the wage and hour division that you've completed our compliance assistance requirements and that you are certified now to contact the wage and hour office to begin your self-audit. And then continue on the website, more information about actually conducting your self-audit that we briefly talked about earlier. And then finally, more information on the payment of wages to the affected employees. And then we have additional detailed questions and answers about the paid program. By clicking on that link, you'll see there are a ton of questions and very detailed answers, which we encourage you to review prior to participating in the program. So we open up the floor to questions.
Yeah,
Thank you for submitting them. We will begin to start answering them.
Yeah, and now you've kind of had a high-level overview of the basic information we made available online. We wanted to direct you to that information at the outset because a lot of the questions we've received both today and earlier concern information that's already available online. So most of your questions will be answered there, but some may not. We've received a lot of questions so far during the webinar, and we've been keeping track of them here in the office. I'll say that the first question I have is similar to something that's on the webpage. It's essentially, why can't I as an employer do my own self-audit and pay the money that I think is due? So look, our position in wage and hour, and employers got to pay their employees all the minimum wages and overtime they're owed, and employers should correct any mistakes they find expeditiously. But under the FLSA, and this makes the FLSA a little different from other statutes, private out-of-court settlements do not result in a waiver of employees' rights to sue the employer. So if an employer just goes and writes a check to an employee, unilaterally determines how much is due, writes the check, and thinks they have a conclusive release that shields them from a liability, they're mistaken under the FLSA. The law requires that either the Department of Labor supervise the settlement or that it's a court-approved settlement, neither of which would be satisfied if an employer just goes and writes a check. So kind of the purpose of this, well, I'll say also, the FLSA authorizes us at the department to supervise the payment of unpaid wages and allows the employees to accept the payments and release their rights. And when they do, they release their rights to sue the employer for the violations at issue, the violations for which they're being paid. Part of the purpose, well, the entire purpose of the paid program is to resolve these inadvertent FLSA minimum wage and overtime violations, because without going through us or a court, the releases really aren't conclusive. I think that answers the question. Moving on to the next one, Keith.
The next question is, to what extent will wage and hour examine employers' records for violation other than those the employer proposes to bring forward? Part of this process, obviously, is bringing payroll records to wage and hour for us to check the self-audit that has been done by the employer. And if wage and hour discovers additional minimum wage or overtime violations outside the scope of the employer's proposal, we will work with the employer to resolve them as part of the audit. The fact that wage and hour is there, the employer is there. If additional violations are found, we feel like it would be best to resolve them and be done and move on. And so if we see them, we may bring them to the attention and are hopeful the employers will be able to work it out with wage and hour for finality.
Got it. One question I've seen, and that has come in before, and so I'd like to address it now because I think there's a fair amount of confusion on the issue is, look, if wage and hour, for whatever reason, denies an employer's request to participate in paid, is there some secret blacklist that wage and hour keeps of employers that they turn down and then they turn around and audit them in the future just because they requested to participate in paid? Look, if wage and hour declines an employer's request to participate in the program, that request will not, and I emphasize will not, serve as the basis for a future investigation. Unless, I mean, and I have to put in this unless wage and hour has reason to believe that health or safety are at risk. I mean, obviously, if we have an indication that there's some child labor violations or something, then we need to resolve those. But otherwise, I think it's pretty clear. Wage and hour, as a general matter, to the extent it helps you further understand where we're going with this, wage and hour is always ready to help employers understand and comply with their legal obligations under any law we enforce and administer. We're always encouraging employers to proactively seek compliance, to call us and get technical assistance, and the paid program facilitates that. That's part of our overarching objective here. We want to work with employers, all good faith employers, to resolve inadvertent minimum wage and overtime violations, and no, we're not using a request to participate as the basis for a future investigation if we decline your request. So I want to be really clear about that up front. I know there's been a fair amount of anxiety about that I've, at least from what I can deduce from the questions we're being asked, and I'd like to put that to rest.
Another question we received is, can you see all the compliance assistance materials that I just went through in a 12-step process? Is there a way to review those independently of actually having to go through that process? And the answer is yes. All of the materials that we bundled as part of the compliance assistant review are publicly available on our general website. We simply packaged a group of material that succinctly walks users through the basics and explains compliance requirements, most likely to apply to the paid program, but all of our compliance material is always available on our website and can be accessed whether or not you are interested or going to use the paid program. Also, the FLSA tutorial videos that appear as part of the compliance assistant review that we watched earlier are available anytime. You could find those at dol.gov WHD/FLSA/videos.
Got it. Next question I have is, I was wondering if I could talk with wage and hour to get WHD, wage and hour, to get my compliance question answered without formally entering the paid program. Short answer, yes. Employers can always call the wage and hour division at any time and speak with a trained professional to have your questions answered, regardless whether you're interested in participating in paid. It's not necessarily an either-or choice. It's our mission in wage and hour always to improve compliance as broadly and as efficiently as possible, to be frank, and to educate employers, as many employers and employees as we can, efficiently and effectively about what the law requires. I think, as I stated earlier, we at Wage and Hour always encourage employers to proactively seek compliance and technical assistance to comply with the laws we enforce, and that is regardless whether they're seeking to participate in paid.
The next question asks, does the paid program require employers to include former employees in their back wage calculations? The answer to that is yes. Like any other wage and hour enforcement action under the Fair Labor Standards Act, back wages are computed for all employees affected within the statute of limitations, regardless of whether they are current or former employees.
Shuffling for some more questions. Here's one. The paid website says that employers must pay all back wages due by the end of the next full pay period after receiving a summary of unpaid wages. However, it is our understanding that payments need not be made unless employees agree to waive the claim. This may result in a short time period for the employer to notify impacted employees and receive their signed waiver before processing payment. Does DOL have any guidance for employers who may wish to give employees a longer period of time to consider their options? It's a good question. So I'll start at a high level. The commitment and the ability to pay back wages expeditiously is a requirement to participate in PAID. The program does require that employers pay all back wages due by the end of the next full pay period after we issue the summary of unpaid wages, and to provide, further than that, in addition to that, to provide proof of payment to wage and hour expeditiously. But, we at the division, we do recognize that the timing of certain payments will require review on a case-by-case basis, and fortunately, the nature of this pilot program really allows us to examine the circumstances under which, the fastest payment can be made that's possible. So our goal with this program is not to rush employees into making a decision or give them an arbitrarily short timeline for doing that in terms of whether or not to accept a payment under PAID. What we're really trying to do is provide resolution for potential violations without the costs or delays of litigation or other options, and to get employees paid the money they're owed faster. So yes, I think we do recognize that some situations the timing of certain payments would require review on a case-by-case basis, but the statements on our website about the timing of payments under the program is the general rule.
We're getting a lot of questions on whether or not we anticipate expanding this pilot program to include other provisions of the FLSA in addition to minimum wage and overtime, or to other laws enforced by wage and hour at the conclusion of this pilot program. And after the pilot program ends, we're going to assess whether it is appropriate to expand this program to other provisions of the FLSA or other laws that the Wage and Hour Division enforces, such as the wage requirements in H-1B, H-2B, H-2A, Davis-Bacon Act, the Service Contract Act, or the Family Medical Leave Act. Right now, it's just for the FLSA minimum wage and overtime, but we certainly are going to take in your comments and look about if we want to expand this program more broadly.
Next question is, what if during the course of a self-audit under PAID, an employer discovers additional compliance issues that were not identified at the onset of the audit? Great question. So I think we say on our website, to some degree, if Wage and Hour discovers additional minimum wage or overtime violations under the FLSA that were outside of the employer's proposed scope of the self-audit, we'll ordinarily attempt to resolve them as part of the audit as well. Our expectation generally with this program is that employers who choose to participate are coming forward in good faith to improve their compliance across the board and to get any back wages that are owed paid quickly. Expanding the scope of an audit, I think, to include any collateral issues that the employer discovers in good faith later in the process is consistent with this overall goal, and so that's what we'll do.
Another question we're getting is about state law claims, and if the PAID program can also provide a release for claims arising under state law. And under the Fair Labor Standards Act, Wage and Hour may not supervise payments or provide releases for state law violations. However, the PAID program does not preclude an employer from separately settling claims as allowed under their state's law.
One question we also received a couple minutes ago is how long should employers, how long will this program take, start to finish, once you contact us requesting to participate in PAID? And, I'll say part of the purpose of this pilot is to, for us to learn about the process and see what works and what doesn't, but at this point we expect that audits conducted via PAID will typically take fewer than 90 days to complete. And we expect that to be the case. Time will tell, but that's the expectation, and I think it's very realistic from what I know.
Okay, the next question coming in is Wage and Hour prepared to handle 7K exemption under the Fair Labor Standards Act, which deals with fire department personnel, whether it be overtime, regular rate, calculation disputes? And the answer is no, not yet. This is not part of the pilot program. Again, we welcome your input how to expand this program after the pilot program's ended, but for now, 7K exemption is not included in the paid program.
And along with that, I also see that there's a question about whether, matters arising under the H-1B program or 14C of the FLSA concerning the payment of sub-minimum wages, whether that can all be brought into the, can be resolved via the paid program. The answer is no. At this time, it's just limited to minimum wage and overtime violations under the FLSA.
Another question we're getting is regarding how long the process will take. And Wage and Hour is expecting the audits conducted under the paid program to typically take around 90 days.
Yeah, I just answered that one. Keith, he was distracted doing the good work over there. He's looking for more good questions. I guess we both agree that it's a good question, which is good. The next question I have is
We could take them away.
Hold on just a minute. Can the employer work with outside counsel to submit information? Yes. Yes, we are not barring employers from working with lawyers. We don't want to deny you your right to any representation. I think the same goes for having an accountant or other representative. Whatever representative you want, I think we're not going to bar that. That's completely fine.
And another question we're getting is about the Freedom of Information Act, and is the data or information provided in connection with the paid program subject to the FOIA requirements? And the answer is that self-audits under the paid program are subject to the same FOIA requirements and defenses as any other Wage and Hour Division investigation or audit.
So there's a question about the statute of limitations, what's the look-back period for how broad is the scope of these self-audits? I will say that the look-back period we're using is 2 years. Obviously, if the compensation practice at issue was not in place 2 years ago, but say started 6 or 8 months ago, that will be the natural scope of the self-audit, but the max look-back is 2 years.
Another question is, what happens to back wage payments for former employees who cannot be located? And this is typical as in all wage and hour enforcement actions. Back wages for employees that are earned and willing to be paid, when we are unable to find the employee, they are sent to the U.S. Treasury, where employees can then claim it for a period of up to 3 years after the action.
So as we've been here today, I've seen multiple questions come in about comp time. A lot of employers are curious whether they, if they owe some money in overtime, if they can make the payments essentially via comp time in lieu of actual cash payments. The answer is no. Even if you're a public entity and can use comp time, that's not a permissible payment in the paid program, at least not, for purposes of this pilot. I think that resolves that issue.
And a issue that we raised during the actual presentation, and we really want to emphasize this. What happens if you've already found the violation, you've paid the workers their owed wages prior to coming to the Wage and Hour Division and participating in the paid program? That does not count because the department has not supervised. So we encourage you, if you want to participate in this program, wait till you work with us before paying the employees. This way, Wage and Hour can supervise it and ensure it's done correctly.
So one question we just received is, will I be penalized if any violations are found? So Great question, and a core feature of the program. We do require payment of all the back wages due. So if you owe an employee $1,000 in overtime or minimum wages that you inadvertently failed to pay, you will have to pay every penny of that as part of the program. However, we at Wage and Hour will not separately require you to pay civil monetary penalties or liquidated damages, which is essentially double payments of the back wages due. We won't require you to pay that as a condition to finalize a settlement in paid. As you know, in litigation, liquidated damages are on the table, as they are with our ordinary investigations in Wage and Hour. So, and that's a hard and fast rule.
Another question is regarding future compliance. You know, as we stated in the presentation, we really, not just during the paid program, but we really want to establish relationships with employers and to help them with compliance in the future. We went over all of our compliance assistance materials available on the website, whether they're fact sheets, whether they're videos. But moving forward, once an employer has participated in the paid program, we're hoping that this is not their last visit. That if there's any questions in the future, that they reach out to their local office and work with their local office regarding the pay practices that may want to be changed, that may want to be updated. This way we can help provide various assistance and materials that already exist that can help the employer make a more informed decision with their pay practices moving forward. So we really hope this establishes a bridge with employers out there for future compliance.
So here's another question I just saw. What happens if the self-audit is not complete before the end of the 6 months? That's a great question. Long story short, we're not going to stop an audit in the bottom of the ninth just because the clock ran out per se. I think we'll continue the audit until it's complete. But again, I encourage all of you, if you know of a minimum wage or overtime violation, or if you learn of one during an audit, come forward quickly and let's get it resolved and get the employees paid. I would not wait until the end of the 6 months. Just as soon as we can, get the process started and get the employees paid, let's get it started. But at the 6 months, I think, as we've also said publicly, quite clearly, even early on, the purpose of this pilot program is for us to see how this program works, and then at the end of the 6 months, we will look back at the results, see what worked, what was the most effective, or what were the most effective elements of the tool, and how we can make it better or tweak it or improve it, or what we should make permanent.
A few people have asked, again, does the program require employees to participate? The answer is no. Employees may opt to accept the payments offered, or they may reject them and retain all of their rights. It is purely the employee's choice whether to accept the payment of back wages due. And most importantly, employers are prohibited from retaliating against the employee for his or her choice in accepting the back wages. And if the employee chooses not to accept the payment, the employee will not release any private right of action. If the employee chooses to accept the payment, releases are limited to the identified violations at the time and for the time period for which the employer is paying the back wages.
So related to a question I answered earlier, there's a question about whether if an employer has already paid wages that it thinks are due to employees after conducting its own audit before participating in the program, can the employer now participate in paid and have them resolved via pay? I mean, short answer, no. And I want to go back to what I said earlier and emphasize that under the FLSA, private out-of-court settlements are not conclusive settlements. And a release of claims is only valid. Release of claims meaning you can't be sued. The release is only valid if it is court approved or supervised by us. And if you unilaterally make those payments before having it supervised by Wage and Hour, then they will not qualify as a supervised payment under the FLSA and will not get a conclusive release unless you go and get it court approved.
So a question has come up that what happens if an employer participates in the program, agrees to make the payments, and then doesn't? What will Wage and Hour do? And I can just assure everyone that if an employer in good faith participates in the program, agrees to make the payment, and doesn't, that Wage and Hour will use all its enforcement authority to recover wages as appropriate. And we are just reviewing some other questions that are coming in. Well, here's an easy one I think we answered. This PowerPoint presentation, this is all being recorded. The slides will also be available on our website, and you'll be able to review this at any time and the material during the presentation.
So I see a question now about, it's about what about companies, and I think the question is what types of entities can participate in the program and paid. And I noticed that, well, I will say that really it's any entity that's covered by the FLSA. That could include governments, local governments. It could include small businesses, big businesses, anything covered by the FLSA, which is a huge number of companies in America. So is there a size? It's another question we got. It's a good one. On a related note, are there any size limits for an employer's participation? So is there a time when the employer is just too big or too small? And the answer is no. If you're covered by the FLSA, regardless how big of a company you are or how small of a company you are eligible to participate in paid. There are no bars based on the size of your company. There's been some questions about records and employers' records and what happens if an employer doesn't have all their records. We're obviously hopeful that the employer will have all their records in compliance with the FLSA record-keeping obligations, but in the event they don't, Wage and Hour will work with the employer and the employees, if necessary, to reconstruct any records to determine the hours worked for these employees, typical of what Wage and Hour would do if an employer that was being investigated didn't have those records. New question, does the employer pay interest on back wages underpaid? The answer is no. I can answer that one easily. What? And the reason for that is because they're paying right away. So there's going to be no need for interest being paid because it needs to be paid at the next payroll period. So Wage and Hour will not be assessing interest on back wages. Right. Correct. So we are running low on questions, which is wonderful, and I think it means that we have answered questions exceptionally well. I'll take a pat on the back for that. So we will keep looking. Let's do a quick review and see if there are any other questions. We appreciate all of your questions today. If you have any other questions in the future, you can always get in touch with the Wage and Hour Division. You can access our website at any time at dol.gov/WHD. If you'd like to speak with someone confidentially as well, you can call us at any time at 866-4-US-WAGE. Or you can visit our website to be directed to the local office nearest your location. And we want to thank you all for participating today. We've received good questions. I hope we provided answers that are satisfying and that you understand. We also have, to the extent we received additional questions that we didn't get to during this webinar, we're going to take them under consideration and take a second look at those. But otherwise, thank you all for calling in. I hope you found this informative. And we encourage you to go to our paid website to play around with it. Again, we are not collecting information on who is, when you add your name in there to go through the slides, we do not know that. So please feel free to use our website and the resources on there prior to participating. We do believe there's a lot of these questions can be answered on our website
or the hundreds of pages of material on the Fair Labor Standards Act available for you.
Excellent. Thanks, everyone.
And that concludes the paid webinar. You'll be able to download the slides as well as go to the paid site for the next few minutes. And as mentioned during the webinar, you will be able to listen to the entire recording as well as download the PowerPoint at a later time. Thank you very much.